Okay, so hello everyone, and welcome to How to Protect Your Intellectual Property with Trade Secrets, presented as part of the 2021 Global Entrepreneurship Week. I'm Evie Cruz, the Nonprofit and Small Business Coordinator at Philadelphia VIP. VIP is the only legal services agency that provides comprehensive pro bono representation to small businesses and nonprofits here in Philadelphia. If you'd like to connect with us after the event, request legal assistance, or keep in touch through our e-newsletter, please email me or visit our website, which I will place in the chat now. Let's do that. And here is our link to our website. Okay, so I would now like to introduce our attorney expert for the day, Sima Singadia Kulkarni of counsel at DLA Piper. Sima counsels clients in all aspects of IP matters, including strategic IP portfolio development, patent prosecution, licensing, and commercialization. Her clients include biotech, healthcare, life science, and pharmaceutical companies, ranging in size from emerging growth startups to multinational global corporations and academic institutions. Prior to working as a patent attorney, Sima worked at the Ronald McDonald Cancer Research Center in the Pediatric and Hematology Laboratory, utilizing cell culture and protein purification techniques to identify antigenic markers. Sima kicked off our first Global Entrepreneurship Week last fall with how to file trademarks for your small business, and we are delighted to have her back to cover another crucial aspect of intellectual property. And with that, I will let Sima take it away.
All right. Thank you so much, Evie. I appreciate the very kind introduction. And thank you to Philly VIP for giving me this opportunity to touch base with you all and share a little bit of my knowledge with you. I hope that you'll leave from this session with some practical tips that will be relevant to how you run your businesses. You might be thinking, well, here's a person with all this extensive biotech life science background. What is she doing talking to us about intellectual property? I don't have a biotech company. Well, just to allay your fears a little bit, I'll just tell you how I ended up here. Basically, in the world, there are two types of property. There's tangible property and there's intangible property. Intellectual property, the field of intellectual property in its most legal basics, I guess, means that it's a field that's dedicated to protecting intangible assets. And when we're talking about intangible assets, we're talking about patents, we're talking about trademarks, we're talking about copyrights, and we're talking about trade secrets. We're talking about aspects of your business that you cannot put in a lockbox, you can't protect with a fence, and you can't put a security alarm around it. It's just something that's intangible, but you know that it has value to your company, and you're concerned about how you want to protect it and what you can do to make sure it's not stolen. So with that little bit of a background, I'll tell you how I ended up here. When I was in law school, I had this nice science background, and I thought that I would go into environmental law and use my scientific knowledge there. What I ended up doing is going to a intellectual property boutique where we focused on patents, trademarks, and copyrights. The patent work that I do is mostly in the technical areas of life sciences and biotech, but the trademark work and the trade secret work and the copyright work that I do is technology agnostic. So whether you have a startup company that has developed a great recipe, or whether you have a startup company that's developing some proprietary software code, I can help you with that. You might be a clothing company that's looking for a way to protect your brand, your logos. I can help you with that by filing trademark applications. So my field covers a lot of different things. My scientific background is really mostly something that I use when I'm working on patent applications. So with that, let me just get started. So I talked a little bit about what's a tangible asset versus what is an intangible asset. For purposes of our discussion today, I'm going to be focusing on trade secrets, which when it comes to intangible assets is at a if you think about this in terms of a spectrum, it's at the far end of a spectrum because it's really hard to quantify and to even register something like a trade secret. So we have to be really creative about how we go about protecting that aspect of your business. Here are just some symbols that I deal with every day. You've got the top secret, you've got a patent, you've got trademarks, you've got registered marks, you've got copyrights, and you've got data. I also touched on this as far as what the four main types of intellectual property are. They are patents. Patents are mostly about protecting inventions. So if you have invented a new knife or a new device of some sort, or a new formula or a new medicine, these types of inventions can be protected with a patent. A patent typically involves filing a patent application. It's submitted to the United States Patent and Trademark Office or other patent offices around the world, where the application is submitted and then reviewed by an examiner. An examiner does a search to see if your application qualifies under several different categories. Basically, you have to overcome the hurdles of whether or not it is novel, whether or not it is obvious, whether or not you've taught how to make and use the invention. Those are just the three basic hurdles you have to overcome. The patent office does an extensive prior art search, and you go through a lot of back and forth with the patent office. And ultimately, if you're able to prove that your invention is indeed novel and unobvious, you will be granted a patent. There is a limited term for a patent. It lasts 20 years from your filing date. When we file patent applications, they are extensive documents, especially in the biotech and life science field. Mostly the applications that I file look like scientific documents. They don't really look like legal documents, because in these documents, we're talking about really the heart and soul of the invention and how it is different from what's out there. We get into the chemistry, we get into the biology, we get into the data, and we present it all to the examiner because we're making a case that you deserve exclusive protection on this invention. So our patent applications range anywhere from 20 to 200 pages, sometimes longer. From the time of filing a patent application to getting a patent application allowed can be anywhere from 18 months to 48 months, sometimes longer. Like I said, there's a lot of going back and forth with the patent examiner in the US and internationally. And the cost associated with filing a patent can be anywhere from, I would say, anywhere from $2,000 to $12,000 to get it on file. But by the time you're done with the examination and by the time you get to allowance, it's going to be, you will have invested a minimum of $50,000 to get to the issuance phase. So a patent is a very robust level of protection, but it is also very difficult to get, and it is also quite expensive. Trademarks are a little bit more user-friendly. Trademarks, we can file for you. In many cases, our clients that might have limited resources or have in-house expertise opt to file trademarks by themselves. In the US, it's pretty easy. You can get onto the United States Patent and Trademark Office website, and there are several tutorials that will show you how to file a trademark application. Even though it's relatively easy, it's quite nuanced because there are certain requirements that you have to be very careful to make sure that you are submitting to the Patent and Trademark Office in the required format. They can be quite picky. Oftentimes, these things which we call specimens, examples of how you're using the mark, will be rejected by the Trademark Office because they're looking for a very particular type of methodology. They're looking for a particular mode in which you're using the mark or the logo. So oftentimes we do recommend that you use a trademark attorney to file your trademark application, but it is something that you can explore by yourself. You can educate yourself and become more knowledgeable about the process. And it is something that you can do by yourself. The filing fee that the Patent Office requires is $275 per class. So it's a lot less expensive than when you file a patent application. The process of obtaining a registration on a trademark is also something that requires a fair amount of back and forth with the examiner, because the examiner is going to do a search to see if there's anything else out there that is similar and will cause likelihood of confusion amongst the relevant consumers. The trademark attorney is also going to look to see if the mark is merely descriptive, if it's generic. So there are other hurdles that you're going to have to overcome when looking for trademark protection, but it is a lot less complicated getting to the point of registration with a trademark than it is with a patent application. One question I often get with these sorts of groups is, how do I know if this mark is even available? The best way to figure out whether or not a mark is available is to have a search done by a trademark attorney. The attorney contracts with a third-party provider. We do a search to see what else is out there for marks that are similar or identical, used in similar goods and services. Once we get those search results back, we review the search results for you, and we provide you with an opinion based on extensive amount of analysis that we conduct. That activity in and of itself can cost anywhere from $5,000 to $10,000. So that's not something that typically falls within the budget of a startup company. So what I advise a lot of startups to do is do your own searches. Start with a Google search. That's always a great place to start. Don't just look at words, also look at images to see what's out there. Then I always recommend that you go to the United States Patent and Trademark Office website. It's a really good resource. You can run your own searches there. It's a little finicky, but you can navigate that website pretty well and see what's out there, because you might find something right away that has your mark and is being used with similar goods and services. At that point, you need to stop investing any more time, effort, energy in developing that mark for your business. So it is something that you should do. I'm going to go through this presentation. You'll see that there's a lot of steps that you can take yourself before you engage an attorney. The more you educate yourself, the more efficiently the process is going to go, and the less expensive it's going to be for you. Copyrights, let me just back up there for a while. Trademarks will last indefinitely. A trademark registration, once you get, will last indefinitely, provided that you submit to the trademark office evidence of continuing use, and that evidence needs to be submitted every 5 to 10 years. There's a specific timeline by which you need to submit these specimens showing that you're continuing to use the mark. Copyrights provide a little thinner level of protection, but they are also something that you can go after yourself. You can go to the United States Copyright Office, follow the tutorials there, and file for your own copyright registrations. The absolute cornerstone of being able to obtain a copyright registration is to be sure that the work that you are submitting is an original work, is something that you created yourself, or you hired someone to create for you, in which case it would be considered a work for hire. Now, trade secrets constitute the topic that we're going to focus on today. So I'm going to actually skip this slide and go to the next slide. One more aspect of intangible property that can be protected is data. So if you're collecting customer data, if you're collecting data about how you run your business, about revenue, about marketing strategies, all of this data can be protected as an asset. And that also actually somewhat falls under the trade secret umbrella. There are numerous ways of obtaining or creating IP. I think this slide should actually be creating and obtaining IP. So you can internally develop IP. When I say IP, I mean intellectual property. You can develop it internally. You might have a startup business where you are developing your own formulas for recipes and those sorts of things. That's internal development, and you can protect it just based on that level of development. You can develop IP with a third party. So if you are perhaps contracting with a developer to develop software for a particular application that you want to put in the App Store, you need to be really careful about how you engage that third party. Who is going to own the software that results out of that engagement? You need to be careful about the contract that you put in place with them, and you need to be very cognizant about ownership provisions, whether it's going to be owned by them, whether it's going to be owned by you, or whether it's going to be jointly owned. You can license IP from a third party. So, for example, if you are looking to develop an app for the App Store again, maybe you license some portions of your software code from a third-party provider. Again, you need to look at the licensing agreement that you have with that third-party provider and make sure that you're dotting the I's and crossing the T's to establish ownership of that IP and to establish whether or not you have the rights to use that IP for whatever purpose that you're intending to use it for. You can also outright buy the intellectual property from other parties. Sometimes, there are companies that have a particular type of intellectual property that they're no longer using. It's part of their asset portfolio, and they want to offload it, and they might be willing to sell it. You might acquire IP when you merge with a company. They may have their own set of trademarks or patents, or they may have their own portfolio of copyrights. And at that point, when you're entering into this merger or acquisition, you need to think about, how is this going to become part of my portfolio as well? How am I going to make sure that I have appropriate rights to not only obtain this IP, but to continue to maintain this IP and also to commercialize it? So there are all kinds of considerations when it comes to creating and obtaining IP and how to move forward with it. So the focus of today's talk is really trade secret. What actually is a trade secret? It's pretty self-evident in most instances what constitutes a trade secret. It's basically anything that's tangible, actually, or intangible that is kept electronically, stored, and it represents secret scientific, technical information, merchandising information, production or management information, designs, processes, procedures, formulas, inventory, improvement, basically anything that has to do with how you run your business that you consider a secret that you wouldn't want to share with a competitor. That's kind of the benchmark. Do you want your competitor to know about this information? If not, then you need to take the appropriate steps to protect that secret. Most trade secrets fall under two categories. One is technical information, and the second is business information. Technical information covers a whole wide range of things. These can be plans and designs. These can be methods and techniques for manufacturing items. These can be engineering notebooks. These can be computer software, and these can also be negative information, because oftentimes, there might be 10 ways of doing things. you've tried nine ways and 9 of them didn't work. But that's very valuable information because you invest a lot of resources into trying out those 9 ways. The one way that works is your trade secret, but all the stuff that didn't work is also your trade secret. Business information, this is also pretty self-evident. Business information includes things such as your financial information prior to a public release, cost and pricing. This is something that you will encounter quite a bit. Oftentimes you've created an item and figuring out what cost the market will bear is a really complicated and difficult task. You know, how are you going to price this novel blend of coffee that you've created? You don't know. I mean, you might be able to sell it $5 a pound. You might be able to get away with $50 a pound. All of these nuanced business practices, all of these things that you do in order to get to the end goal, which is selling your product. Many aspects of that process can be considered a trade secret. So unlike patents and unlike trademarks and unlike copyrights, there is no formal registration process for a trade secret. You can imagine, like if you had to register a trade secret, you'd have to disclose it to an entity, and then everybody would know what that trade secret is, and then that just kind of defeats the purpose of having a trade secret. So there's no real formal overseeing body like the United States Patent and Trademark Office oversees patents and trademarks. You got the Copyright Office that oversees copyrights. There is really nothing for trade secrets. For trade secrets, what we have is the Uniform Trade Secrets Act that was passed a couple of years ago that sort of works with state laws as well and provides a framework for entities to develop their trade secret program around and for courts to go after violations of trade secret protection, such as trade secret misappropriation. It provides a framework for you as a trade secret owner to go after people that have misappropriated your trademark, employees that have left and taken your trade secret information with you. It provides a little bit of guidance and a foundation, but we don't have an overarching body that oversees trade secrets. There are many things that courts will take into consideration when determining whether or not you have a trade secret. And these are a few of the items, a few of the considerations that a court will think about, which means that you should think about when you're putting in place your trade secret program. Make sure that it is information that is not known outside of the business and protect it accordingly. Make sure that the trade secret that you have is only known by your employees and actually only those employees that need to know. A trade secret, a court is going to look to see how diligent you were about protecting the secrecy of the information. They're going to look to see how valuable the information is. They're going to look to see what sort of resources you invested in protecting that information. And they're also going to look to see how well you protected that information. I mean, if it's something that's in a binder, did you just leave that binder out on your desk or in a public place every day before you went home? Or is it something that you were really diligent about protecting? So when we talk about best practices, and we're talking about trade secrets, there are a couple of things that we always advise our clients. First and foremost, identify your potential trade secrets. Make sure that what you're trying to protect is actually a trade secret. If you have any doubt, go ahead and protect it anyway. Make sure that you protect it to the point where the information is not easily available to everyone. It's only available to people that need it. And make sure that you implement strategies by which your trade secret cannot be reverse engineered. Determine whether or not keeping the information secret is viable, or whether or not you should just think about other modes of protecting. So when it comes to say, for example, a recipe, you might want to keep that recipe a trade secret. Further in the presentation, you'll see that recipes are actually many times the subject of trade secrets, like the Coca-Cola formula, or like the KFC recipe for its special mix. Oftentimes, recipes are kept secrets, but sometimes it's not possible to keep it a secret. So you may just not have what you need in order to protect a recipe as a secret. So in that case, is it better to go ahead and file a patent? What happens when you file a patent is that the information that you put in the patent application becomes public after 18 months. But you might be willing to take that because what you have is exclusivity for whatever's in that patent for 20 years. So whereas a trade secret is going to be a trade secret for an indefinite amount of time, assuming that you're able to protect it, you may want to count your losses and say, yeah, you know what, I'm going to be happy with a 20-year term of exclusivity on this recipe. I will disclose it to the public. And after 20 years, I won't have exclusivity anymore. But at least for 20 years, I know I'm the only one that can have access to this recipe. I'm the only one who can use it. So it's a cost-benefit analysis that you kind of have to run and make sure and see if that works best for your company. Back to best practices, we highly recommend that you include an information security trade secret policy as part of your employee and contractor onboarding process. So when you hire new people, when you engage with third parties, you include a trade secret policy. Oftentimes this involves making sure that a confidentiality agreement or a non-disclosure agreement is signed by all parties involved. Once you engage a third party or an employee, you need to have a provision that says if you have access to any trade secret information, you need to return it to me or you need to promise to destroy it once we're done with our relationship. You need to implement procedures for managing disclosure of your trade secrets if and when it is necessary for particular commercial transactions. And like I mentioned before, you need to implement procedures for managing disclosure and use of third-party confidential information you receive in order to make sure that you're also not going to be in trouble for indiscriminately or inadvertently disclosing other people's trade secrets. So this is basically kind of a repeat of what I just said. You need to identify information that you consider trade secrets. You need to be selective. You can't protect everything, right? So certain aspects of your procedures, you do need to be able to disclose. Make sure that you focus on those aspects that you consider to be proprietary and secret and particular to your business, and make sure that you protect those. You need to label documents to the extent possible. Consider using words such as confidential with documents that expose aspects of your business that you consider to be trade secret. You need to limit access to these documents, and you need to instruct all employees. Make sure that your employees are knowledgeable about what is considered a trade secret for the company, so that they're all working from the same page, so that they all know what they also need to protect. You need to implement security measures. Oftentimes that means, putting things back where they came from. That involves, it can be something as simple as making sure that the binder that has all that trade secret information in it is returned to a locked filing cabinet, or it can be a little bit more complicated than that, such as making sure you have a security system installed in your work facility. Of course, there are passwords for your computer systems, include confidentiality provisions on all your documents, Make sure that you don't accidentally reveal your trade secrets. Oftentimes when we're doing presentations or we're doing pitches, we might accidentally reveal what is, the heart and soul of your business idea or your manufacturing method. Just be careful that you're not disclosing everything. Go back and periodically review your business materials to make sure that your trade secrets haven't been disclosed, and require strict confidentiality when it comes to dealing with any outside persons. Also, be sure that you're aware when you're dealing with entities outside of the US that trade secret protection varies significantly from jurisdiction to jurisdiction. In some countries, trade secret is really not something that is well respected. So you need to be extra careful when you're dealing with entities outside of the US. You cannot always expect the same level of commitment to confidentiality. So just be extra vigilant when you share proprietary aspects of your knowledge with third parties outside of the US. The other things that are written here, like updating written policies, periodic training sessions, making sure that your employees are accountable, holding exit audits. These are all aspects of your business which are pretty self-evident. I mean, I think if you're running a business of any more than 2 to 3 employees, you're probably attending to these practical methods of making sure that your proprietary knowledge is protected. Evie, will you be sharing these slides afterwards, or?
Yes, I do plan to share the recording as well as the slides themselves with the participants so they can refer back to this.
Because a lot of these are like checklists that people can go back and kind of look and see, am I doing this? Should I think about doing this? How? I don't remember what she said. What was point number 14? So I think it'd be helpful for people to have the slides. I wanted to share a couple of famous trade secrets with you all. The Coca-Cola formula has been a trade secret since 1886. I don't know how they've managed to keep it a secret, but they have. And their annual revenues are in the $10 billion range. The KFC recipe for their herbs and spices is also a very well kept secret. I think one of the ways in which they continue to keep it secret is they have one company that blends part of the spice recipe and another company that mixes the rest, and then it all comes together. Neither entity knows what the other entity is really doing, and then that's how they have managed somehow to keep it a secret. WD-40, which you didn't know, is also a secret. I thought it was interesting to include here that WD means water displacer, and it was the 40th attempt by the chemist that developed it. And they've managed to keep it a trade secret as well. Nowadays, I think most companies would have filed a patent application, but they've kept it a secret for many, many decades. The Google search algorithm is also a secret, as is the McDonald's special sauce, as is the recipe for Thomas English muffins. The nooks and crannies, how they achieved those, that whole methodology is a secret. The rest of my slides actually talk about patents, and I just thought I would leave this in there so that when the slides are distributed, you have a framework or you have some basic bullet points that you can review when you're thinking about putting in place a patent prosecution strategy or a copyright strategy or a trademark strategy. I just kind of wanted to give you this as a complete guide if you have questions along these lines. And then I also included a couple of useful useful websites that you can use to do some basic research as you get started. The first website up here, wipo.org, is great. I always go there for running patent searches. The next website there is really good for running trademark searches. In Europe, the next website is one that I go to 24/7 for running patent searches and trademark searches. And then there's the copyrights website as well that you can use to also run searches. So all of these you can use to run searches and get tutorials as far as how to go about protecting patents, trademarks, copyrights. Not so much trade secrets, but it's a really good set of resources for you to start with as you're setting up your businesses. And that's actually, I wanted to leave time for questions. So it's a little bit about myself. So I thought I would kind of end there. And then I'd love to have a conversation with you all about what you're doing and what your business needs are.
Thank you for that, Sima. This was a very informative presentation. And I did get one question in the chat. So feel free, everyone else, to keep sending me questions in the chat or send it to the group so I can read them out loud. So our first question is, can an idea or a novel way of doing something be a trade secret?
Yes, absolutely. It can. It absolutely can. An idea, it's usually best to start out protecting it as a trade secret. Once you have reduced that idea to practice, once you've got that thing going, you can revisit your decision to keep it a trade secret as long as you haven't offered it for sale or done anything else that has put it in the public. So if you feel like, yeah, I want to start out while I'm developing my idea, I'm developing this methodology, I want to keep it a trade secret, absolutely keep it a trade secret. Then once you get to a certain point where you might want to start commercializing it or working with third-party providers or partners or pitching it to a large company for them to perhaps acquire the idea, you may want to talk to a patent attorney or an IP attorney about what are your best options for protecting that idea. They may suggest that you keep it as a trade secret, in which case you want to make sure that you follow all those practical steps for keeping it a trade secret. Or they may say that, since you're going to be offering it for sale, and since it might be a little easy to reverse engineer, even though it hasn't ever been done before, you should really consider filing a patent application. So it really depends on what that idea is.
Okay, great. And then our next question in the chat is, what if the investor is not willing to sign an NDA or non-compete clause?
Yeah, that happens quite a bit. That does happen quite a bit. In that case, when my clients come to me with questions like that, we are usually we're working on a scientific discovery of some sort. And I've got a small startup biotech company that wants to partner with a large pharma company. And the pharma company is like, yeah, no, I'm not signing any NDA. In that case, what we do is we file a provisional patent application. We put everything in there and we file the provisional patent application. The provisional patent application provides you with a certain level of protection. The provisional patent application is never published. So if I'm a small biotech company and I'm talking to a large pharma company and they say to me, we're not going to file the NDA, but I really want to talk to them because I know that they're going to love my idea. They're going to want to invest in my company. What I'm going to do is I'm going to file a provisional patent application as close to my meeting with the large pharma company as I can. So say I file it today. I file it on November 10th. I file my provisional today. I put all my information into that provisional application. I file it. I don't have the money to hire a lawyer. So what I do is I explain my invention really, really well, and I file that provisional directly through the US Patent and Trademark Office website. Filing fee, I believe, is $75. So it's quite affordable. You file that. Talk to the pharma company, and you disclose everything that's in that provisional application, but not anything more. And the pharma company is really impressed. They love your idea. You tell them, you very clearly mark on your presentation that this is patent pending, and so that they know that you were careful, you protected your idea, and they also know that you're sophisticated because you went to that extra step of filing a patent application. And you've put patent pending on all your slides, all your materials, you've put it out there for them. So they invest, you form a partnership, and then 12 months from the time that you file the provisional application, you convert that provisional application into a regular application, and then you go down the patent route. You will have given up trade secret protection at that point, because the patent application will be published at some point during the examination, typically 18 months from when you filed the provisional application. Now, what happens if the pharma company decides not to invest in your company and not to partner with you? What do you do then? At that point, you've already disclosed all that information to the pharma company. So your best bet is to continue down the patent route. It's very hard to backtrack at that point and say, okay, now I'm going to go back and keep it as a trade secret, because you've already disclosed that information. It's very hard to go back. You can't do that unless when you talk to that big company or the partner and you disclose to them only, the basic information that's going to get them engaged enough to want to sign an NDA or to want to enter into a partnership, at which point you can continue going down the patent route. But I'm afraid when we are small entities dealing with these large entities, it's very hard to get around them not filing, not agreeing to sign a confidentiality agreement, but it does happen. Sorry, I hope that answers your question, but it's kind of a case-by-case analysis.
Well, yeah, thank you for that. And feel free to add any follow-ups there. Does anyone else have any questions? You can write them in the chat. You can also unmute yourself if you want to just say it out loud too. We have a bit more time here. Anybody? I know we had a lot of information thrown at you today, and we are going to share everything with you so you can refer back to it as you're making your decisions about how to.
I have one or two questions.
Okay, great. Go ahead, Ruth Ann. This is my AmeriCorps Vista who works with me at Philly VIP.
So I guess my question is in regards to intellectual property in general. What should I look out for in terms of if I develop some sort of intellectual property while I'm working at another place? Like, say I'm working for another company, a software company or a gaming company, and I decide to develop something either on my own time or not on my own time. I guess it depends. What should I look out for to make sure that that intellectual property is mine and doesn't accidentally go to the company that I work for?
First of all, employee agreement with your employer to make sure and see what the details of your terms of engagement are with your employer. This will be addressed as to, if you develop anything, who does it belong to? That would be your first starting point. Second of all, I would advise you not to use any of your employer's equipment when developing any product or any software or anything along those lines. I would also advise you not to do it on your employer's premises. Make sure that you separate as much as possible, so that there's no question as far as did you use your employer's resources in developing the product that you developed.
Thank you. I guess my other question is how reliant can one be on, like, especially in terms of recipes, which from what I understand are kind of difficult to copyright? How reliant can one be on social norms to protect like sort of trade secrets? Because I assume that like when these are violated, it can get pretty expensive. So how, other than the tag that you mentioned, what other protection can one look for in terms of trade secrets?
What do you mean? Like how, what are the alternative methods by which you would protect a trade secret? Or yeah,
I suppose so, yes.
yeah. So a trade secret is definitely difficult to protect just because of the nature of, you know, that asset. It's hard to protect. There are a lot of activities, there are a lot of measures that you have to take in order to protect it. There are things that you can do in order to protect that proprietary aspect of your business. If it's a recipe, for example, you could file a copyright application on the recipe itself. That's going to provide you with a thin layer of protection. You could file a patent application on it. But as I covered in the presentation, it is difficult to obtain a patent, and it is expensive to obtain a patent as well. So again, that becomes a business decision as far as how much you want to invest in protecting, say, for example, it's a recipe. It becomes a business decision. But you do have to know that there are timelines, and then there are certain hurdles that you have to overcome. So if you decide that, okay, this recipe, I think I do want to protect it as a patent, you have to do that before you disclose the recipe publicly, or within 1 year of disclosing it publicly in the US, because in the United States, we have a 1-year grace period. Outside of the US, there's no grace period. So that's something that you have to be mindful of. Also, for patents, you have to file a patent application before you offer it for sale. So if you are someone that's developed a really novel recipe for donuts, before you offer that recipe for sale to Dunkin' Donuts, you need to be sure that you file the patent application, because an offer for sale constitutes a bar. So there are many things that you need to be mindful of before you decide how you're going to protect your proprietary information or your methodology. Timelines are very important.
Thank you.
And I do see that we've had a late comer to the presentation. We're just in the Q&A section now. So if you have any particular questions about intellectual property or trade secrets in particular, now is the time to either put them in the chat or unmute yourself and ask our attorney expert whatever you need to. We have time for 1 or 2 more questions before the end of the hour.
There are a lot of resources out there that you can turn to, you know, to just kind of set up a basic framework of knowledge as far as how you're going to protect your business. And there are so many aspects of your business going to require protection. One resource that I recommend to a lot of startups is DLA Piper Accelerate. You can just Google DLA Piper Accelerate. And it has a great toolkit, you know, contracts, employment agreements, articles of incorporation, a lot of free content that's put out by DLA Piper. You can find these sorts of documents out on the web, but you know, when you find these materials through a reputable law firm like DLA Piper, you have a sense of comfort and you can have a sense of security knowing that, yeah, you know, these are really good starting materials and you don't have to start from scratch.
And I just put a link to DLA Piper Accelerate in the chat for you guys to click on. It's exactly what Sima was talking about. It's a really great resource for all sorts of business needs. We are a resource as well. If you'd like to talk to a lawyer one-on-one, you can speak with an attorney like Sima. If you use our application, I will put that in the chat again. Okay, there we go. Well, if no one has any other questions, we're coming up on the top of the hour. So again, I'm going to share the slides and this recording with everyone after we hang up here. I want to thank Sima again for sharing her time and knowledge with us today. And I want to thank you all for joining us. I hope you have a great rest of your day and a happy Global Entrepreneurship Week. And keep an eye on our calendar. We will be adding new events for early 2022 with different topics, not just IP. We do things such as contracts and business formation and all sorts of good things there. So with that, I will let you all go, and I'll see you all soon, hopefully. Take care.
Thanks, everybody.